How does USCIS raises the issues of misrepresentation in marriage petitions? Marriages, green card based on marriage. In this video, we are going to lay out the foundations for you, and we're going to explain to you in 6 ways, right? How USCIS come up with those issues of misrepresentation, and we'll tell you whether or not you need a waiver. My name is Bijoux, Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex US immigration cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. And also please follow me on Instagram, where we are answering questions on immigration based on employment, right? We're talking about employment-based immigration, we're talking about investment, and we're talking about, just really, to be honest, the business side of immigration. Let's get right into it. 6 ways, okay? The first way is when they look at the manner by which you enter the US. Remember this. When someone comes to the US with B1, B2 visa, the 90-day rule explains that you cannot adjust status within 90 days of your physical presence in the US. Because why? Because you're raising the assumption of misrepresentation. It means that you misrepresented your facts at the consulate, and now you came here. Remember, B1/B2 is a single intent type of visa, and now you just got here. 90 days later, you got married, and 90 days later, you are adjusting status. This is a big no. It's a wrong move. Just don't do it, because you're gonna raise the assumption of misrepresentation. The issue of misrepresentation is gonna be raised, and quite frankly, USCIS is gonna deny a petition, and then you will be forced to apply with a waiver. Happens a lot. That's just number one. The manner by which you enter the US will determine whether or not there has been misrepresentation in your case. Okay? Number 2, using false documents. Okay? This can even raise to the assumption of fraud. Remember, some people get here because of the fleeing of the country, right? They get here with somebody else's documents, right? They get here with a passport that was stolen, or just false identity. And now they have to, let's say they get married later, and they have to apply for adjustment of status. Well, remember, with adjustment of status, you have to show parole or inspection, right? Admission and inspection, or parole and inspection. Those 2 things, or one. So this is how it comes into play. So now you're gonna show somebody else's passport because you have to meet the inspection requirement. But if the document that you're showing really is not you, it's pretty much a stolen identity, false document. Really, it's not even an assumption anymore. It's a fact that you misrepresented your facts at the border so that you can get in. And now you want to adjust status while a waiver is required, because otherwise, how are you going to adjust status? Because of that misrepresentation. And this is, quite frankly, sometimes it really doesn't work. You have to really fight it. You have to have case law to support your claim. Because sometimes it works with people who are applying for asylum, because they can show that they were fleeing the country, and they had to use whatever manner or whatever document they had at their disposition so that they can get here to safe haven, right? But if you're doing marriage based type of petition based on green card, my friend, you have to apply with a waiver, because really the assumption is that, actually, it's not even an assumption, it's just a fact that you misrepresented everything. It pretty much raises to the level of fraud. Waiver is required. Okay? Then we have number 3, Failure to disclose, I'm reading from my note, okay? Failure to disclose children or previous marriages. Well, if you fail to disclose that you have children, or you fail to disclose that you've been married before, and then they find out later, really, it looks like you're just lying on the oath, really, on the application, and that's misrepresentation. It can lead you to a denial of your green card marriage type of petition. So a waiver is appropriated under those circumstances. Really, a waiver could be something that you can use so that they can actually waive that misrepresentation. And quite frankly, this one, I really have to reiterate on this one, because people, when people are going through the consulate for interview, okay, please, if you have children, just state the facts the way they are. If you have been married before, just state the facts the way they are. It doesn't really help you to lie over there and then come here later on, start fighting with attorney's fees and waiver and USCIS fees and denials and appeal. So it's just better for you to just tell your story the way your story is, okay? That's number 3. Number 4, some people, they take I don't know if it's a confusion, but some people, instead of saying that those children are my children, biological children, and those are adopted and those are stepchildren, you have to be able to make a difference, right? Especially if the question really specifically asks you that. But if the question doesn't ask you that, maybe you say just children. But if they're not your children, really you have to say that they're not your children, because if they ask you for a DNA and they're not your children, like they're children because they're stepchildren, they're children because they're adopted children, and now you go to the DNA and they find out they're not your children, now you start explaining yourself. And if you put, because some people really put biological children when they are not, it becomes a misrepresentation. Now how are you going to waive it? Well, it's good luck, right? Because now you're applying for a waiver, try to explain yourself and hope that it gets granted, okay? Number 5, not being free to marry. The first question we ask our clients is this: are you free to marry? Or both of you, are you free to marry? Some people enter into a marriage type of agreement, or they get married legally. Meanwhile, they're not legally divorced, or meanwhile, the divorce was fake. Even if you didn't know that your divorce was fake, but the moment you come to realize that the divorce was fake, you have to actually divorce here, then divorce over there, then remarry to make it a legal marriage. Otherwise, USCIS is just going to deny you your case, because you remember USCIS reserves the right to investigate, right? If you give, it happened a lot really with my clients from Nigeria and Ghana. For some reasons, USCIS really just assume that they're doing fake marriages or fake divorces, so they have to really verify over there in the country. And sometimes, not all the time, sometimes they're right. Those marriages or those divorces over there are so fake, and here you get a denial. So you have to make sure that you are free to marry. Otherwise, you're gonna need a waiver of misrepresentation. Even though it was not done knowingly, you still need a waiver of misrepresentation in order for that petition to be successful, okay? Sometimes you might not need it and just start over with your application, but most of the time you will need it. Lastly, based on what we've done, right, as a research, is adjustment of status in court. Remember, when somebody is adjusting status in court, especially if the marriage took place after the person has been issued with the person has been served actually with a notice to appear, then the person goes and get married. Now they wanna show marriage in court as the defense, right? Adjustment of status. Remember that the assumption or presumption is that this is a fraudulent marriage. But still you can overcome that presumption or assumption by proving that this marriage is a bona fide marriage, it's a good faith marriage. And we know how you prove it with documentations, with birth certificate of children, if you have children born into the marriage, etc., etc. And you should really support your thing. If the DHS alleges that it's fraud, then you should support that too with a waiver in court, because the assumption is really that this is a fraudulent marriage. This person just got married because now they find themselves in removal. So, and sometimes even when the marriage happened before the actual notice to appear is served to the client, still sometimes the court will assume that this marriage is fraudulent, right? So you have to be able to prove bona fide marriage so that you can rebut, okay? Be able to overcome that assumption or presumption of fraud in the marriage. So those are the 6 ways how USCIS raises the issue of misrepresentation. And we added one for the court too, how the court has the assumption of misrepresentation. That one happens when you are in court in removal proceedings and you try to adjust status based on marriage. The assumption is that fraud has occurred, okay? But you can still overcome it by provided evidence that this marriage is a bona fide marriage. This is it for today. If you need the consultation with me, please call 202-751-2180. Email Bijoux.ngwandaesq@gmail.com. Consultation fees apply. Until next time, bye-bye.